We're going to be talking about the hottest topic, well, one besides tariffs, in the world today, which is AI. And the title of today's webinar is Navigating Trademark Creation and Protection in the Age of AI, because as I'm sure many of you have seen, clients are now starting to use AI to generate new names, new brand names, even logos. So there's a lot of interesting things around that. We'll also kind of cover some of the Trademarks 101 stuff that comes along with the creation of new brands, along with the AI component of it. This presentation was not created by AI, so if you see any errors or omissions, those are purely human. And Eric and I, Eric Perrott, who is the other partner here at the firm, we are here in, this is that we're not AI generated yet. Like maybe in 5 years, Eric, we don't even have to do this. We could just put our bots in here. Yeah. But for today, you still get us in person. So enjoy it while it lasts. A little bit about our firm. We are actually just celebrate our 17-year anniversary here in March. Opened in March of 2008. We've got 9 lawyers, 4 paralegals spread up and down the East Coast. We're fully remote. And so we just happen to have people sort of all over the place at this point. In the past 17 years, we just do trademarks. So we've registered over 8,000 US trademarks for clients. We've also registered hundreds of other trademarks around the world. One of the fun parts about trademark law is you can kind of quarterback, brand protection on a global basis and work with attorneys in various countries to help your clients. So we do all that kind of work. We also settle a lot of disputes. In the trademark world, it's encouraged to try to settle things without litigation. It's a lot less expensive and typically a lot better resolution for clients. So we're pretty good at doing that. We also do litigate when we need to. We've done a lot of work with the USPTO in overcoming refusals of clients' trademark applications. And just last year, we registered 833 trademarks for clients here in the US. So just to give you an idea of the breadth of our trademark practice. Our clients come from all 50 states, which is another fun part about trademark laws. We don't have to be confined to a local area. We can kind of work with people all over the place. And actually about 30 or more countries around the world, we have clients that need assistance in protecting their marks here. So we help them. So also just a fun aspect of our practice and getting to talk to people all over the place. So this is just an outline of what we're going to cover today. You might be familiar with it, but obviously we're going to talk about what is AI. We're going to then get into how AI works in the trademark creation and clearance process and how people are using it. Get into the idea of what we need to do to mitigate the risk of trademark infringement when we're using AI. Also going to touch on copyright issues because trademark and copyright law, it sometimes go hand in hand. So we're going to talk a little bit about the copyright issues that can come up when using AI as well. Eric and I both have our top tips that we'll also share, or I don't know if top tips or favorite tips at the end. So that's what people got to stick around for, Eric. I mean, that's my, yeah. You always got to leave that. What do you call that? You got to make sure they stick around for the whole video. So that's what we're going to hold out for.
That's the after credit sequence for our webinar.
Yeah, the blooper reel. Yeah.
Yeah.
So, just to kind of get us all on a baseline for those of you that are joining us that might not have been on a call with us before, understanding what a trademark is kind of fundamental to the rest of the presentation today. So really quickly, trademark is meant to act, the technical term is it's a source identifier, meaning that it needs to identify the source of a product or service. So if I see a Nike shoe, I know that Nike Corporation is behind that shoe. And that's the idea, is that consumers can use trademarks to identify what company's behind a particular product to ensure that it is the product they want to buy. A lot of different types of trademarks that you can register. Business names, product names are kind of the most common. Slogans, logos are also things that you obviously see all the time. There's also things that might not seem as obvious. Certain types of packaging, which we call trade dress, might be protectable. So you think of like the shape of a Jack Daniel's bottle, or the maker's mark, the cap on a maker's mark bottle with the wax stripping. Sounds can be protected. You think of the Netflix ta-dum when you sign on, that's a protected trademark. Colors, patterns, shapes, these are all things that can become protectable as trademarks. Those are a little bit harder depending on, you have to have a lot more market penetration, but these are all things that can be used. And these are just some, taking Nike as a quick example. The name is Nike, the slogans just do it. You could see they've got, obviously the swoosh is the logo, and trade dress could be like some designs that they have on the shoes. So these are all things that, people can, any new companies creating trademarks are going to say, okay, I need a name, a logo, a slogan. These are all things that people are actually now using AI to start to generate for them. So what is generative AI, especially in the context of trademarks? It is obviously artificial intelligence that can help people generate names, logos, and slogans. Even newsletters, other marketing materials like blogs, can be created using this technology. The most common ones you may see out there are OpenAI's ChatGPT. You have Google's Gemini. Microsoft has a product called Copilot, and there's many others. They're all sort of technologically similar in the sense that they're all trained on source material, meaning that you can't just create an AI out of a software code. You have to feed information into the AI so it can be taught how, and have the information available to answer questions it's getting asked, or to generate creative works like a name or a slogan or a logo. So when somebody asks a question, it's always referencing this training data that it's been trained on. And the AI models are basically trained on these data sets that are derived from publicly available information and databases. So where we worry as intellectual property attorneys is that pretty much everything being spit out of the AI, it came from somewhere still. It didn't just come from the thin air like it might come to a human thought. It has to have that come from somewhere, some of that training data. So while it does sometimes generate a novel idea or design based on what it already knows, and it can kind of come up with something fresh enough with that information, the outputs are always going to be rooted in pre-existing information, which makes it dangerous from an IP perspective, because if the AI generates something too close to what's already out there, you could have an infringement issue.
Well, and,
Um,
and part of it, Josh, too, is that it is mimicking. So the way that it works is that it wants to answer the question that you gave it, or the prompt that you gave it, and it is not looking for any kind of objective truth. It's trying to answer what you want to see. And so a lot of the times that might ignore a lot of context. It might ignore a lot of the questions you didn't ask it. It's only going to answer the thing that you actually prompted to provide. And I think that, at least in not just trademark law, but I think all types of law, context is ultimately necessary to understand what you're dealing with. And I think a lot of these AI models, they're going to generate things that look very much like something that someone who knows about the topic would understand. But then just knowing in the back end that this is, Josh, like you said, millions and millions and millions of pieces of information, all pulled from things like Reddit posts and online message boards, and all these kind of things. And if you've ever been on one of those online message boards, you can see legal advice that is just either patently wrong, or only applies in one jurisdiction, or is just a complete misunderstanding of what the law is. All of that got baked into this model. So this is not something that these models they didn't ask permission to grab all of this. So some of the stuff that our audience members likely have posted on the internet has been used to feed these models. And so that's kind of just the base set that we're working with, is this kind of huge amount of information that this model is trying to interpret what you want from all of it. And so that's kind of where we're starting with. And I think it's important to realize.
yeah, thanks for that, Eric. And for what it's worth, Eric's the tech person here. I'm just the guy that like tries to act like he knows what he's doing. But no, and I think that's a really articulate way of saying it. And this is where everybody, you read the headlines of attorneys filing briefs that they use to, chat GPT to create, and that citing like a case that doesn't exist. Like it's not like every data that got pulled into it is correct or accurate. It's just data that it's being fed. And so you really have to take what you're getting, and we'll get into this more, but you have to take it with a grain of salt, so to speak. So before I even get into the next section, just as to let you all know, we do consider this to be a very interactive program today. So we're happy to take questions. If you have questions and you want to put them, the chat looks pretty active. But if you want to put them in the chat as well, we'll certainly get to those. But please feel free, because we we have enough material to probably get us the better part of an hour, but the questions help us certainly make sure we get all the, every to the hour without getting to the end of the presentation a little early. Plus, we think it's always a nice back and forth to hear where audience members have questions. So please feel free to drop them in the chat.
Yeah, there's also a question and answer portal too that we can use
even better.
if the chat's a little busy.
There you go. Yeah, we'll monitor those, and either Lacey or Eric will stop me at some point with those questions. Okay, so the top question we get from clients: can you create trademarks using AI? And the answer is yes, you actually can. And this is a little bit repetitive to what we just talked about, but there's a big but behind the yes, right? Is that you have to remember that AI is trained on existing data. So when it's generating these brand elements, you have to remember it could be based on some pre-existing concept. So we'll get into this in a second, and Eric's going to go through it, but there's a whole clearance process that a trademark should go through once you've come up with a name. And that clearance process is something we've done before AI, right? We used to say somebody would sit down, I always joke with clients, I'm like, grab a bottle of wine and, 10 friends and try to come up with a name this weekend, if you need a name. But, people used to do it that way. Now they're using, maybe some chat GPT assistance. However you come up with a name, you have to research it. You have to make sure somebody hasn't thought of it before you or has something similar. Go through that again in a second, but it's even just as important in the chat GPT world as it was before. The other thing that we always remind clients of is that the AI might create a name that has other problems, not necessarily a conflict with somebody else, but maybe the name it comes up with is just too generic for the particular industry. It might take a common word from the industry and try to say it should be a trademark when it shouldn't be. So the idea that, and I cannot begin to tell you, I probably at least a couple times a week get a call from a client saying, oh, I went on ChatGPT to see if this trademark looked okay, and it told me it was fine. And they really believe it. They're like, so it must be, I don't need you to do anything else, is basically the implication. But I'll look at it, I'll be like, inherently, I know this trademark's not fine because it's not unique enough for your industry, right? It could be too generic. It could describe the products or services, things like this that won't even get it past, the initial test at the USPTO. So those are other things to be aware of. And logos, you'll probably hear me say this multiple times. I think they're especially risky. There can also be copyright issues involved because there's artwork involved in creating logos. And again, the AI is using stuff from existing artwork to create some new artwork. So you run the risk that the logo could be problematic. Logos also just, as someone who does a lot of clearance work, logos are harder to clear than names because the way you have to search logos at the USPTO, it's just an imperfect science. And, everything's an imperfect science. But the design elements that you have to search and the way the PTO's system works, it's just, I always tell folks, it's not nearly as accurate as when we're searching words. It just can't be yet. And so because the logos could be even riskier the way that AI is creating them and they're harder to clear, a lot of times I really just recommend trying to use a really reputable and good graphic artist to come up with something unique instead of using the AI.
And in the chat, someone asked that we've talked that it uses pre-existing concepts, and can't you argue that everything comes from previous existing concepts? I think really the answer is that is certainly one of the arguments is that every knowledge that exists is kind of based on prior knowledge, and I appreciate that. I think that the biggest thing is context and that kind of decision-making process in very subtle ways that we do, and we do it with varying degrees of success, I think, depending on what your own experience is. And I think that's where generative AI can give a lot of information. Some of it might be right, but it is based on information that does not have a particular objectivity to it. That's getting a little bit more into kind of theory than we probably need to for this, but I think that that's where this differs from a human synthesizing knowledge versus kind of a computer doing it, at least, without getting into too much futurism and
we could go philosophical here, Eric. If we need to, philosophy 101. It's been a while for me, but yeah, we can go back to that. I know, it's an interesting point though. It's true. And I
Yeah,
mean, I think, and look, even when you deal with logos, like, I mean, I can't tell you how many times a client has come to us and said, "Oh, I see somebody else out there using my exact logo." And I'll be like, "Well, where'd you get it from?" And they're like, they'll say some online website that they went to. You
right.
have, and then you realize like all the people on there are recycling the same logos and giving them to different people. And so like 20 people end up with the same logo, if not more. So you do have, that's why I say it's like a reputable graphic artist. And yes, I mean, you're going to run risk even in human created content as well. And we'll get into that in a second, but, you know, specifically when people ask us about AI, that's, what Eric and I have just described is sort of where we talk about it. Um, there was another question in the chat that I saw pop up about, doesn't AI make searching of trademarks, especially for logos, easier? There are programs out there, and we'll also touch on this later in the presentation, that claim to use AI, I would put, to do trademark searching. And there's even reverse image searching. Google does reverse image searching, and it's gotten better. There's no question. But because you have to be so technical and so precise in a trademark search to actually give a clearance opinion, um, the technology is not 100% there yet. And it's, look, I don't doubt that in 10 years time, we'll be having a different conversation about how useful AI is in the trademark world, especially when it comes to clearance searching. It's made things easier today than they were 10 years ago, without a question, just the increase in technology. But there's still things it just doesn't find or doesn't understand the context. And so it can't possibly find all the conflicts that might be out there. And again, that's just a risk, as you're trying to de-risk situation for clients. It's just something that we have to be aware of.
Yeah, and I think that there is a fundamental balance between, I'm not sure if any of our audience is on the marketing side of things, but there is this inherent tension between the marketing folks and the legal folks sometimes, that marketing will come up with all these great ideas, or they'll come up with one that is very marketable. You can, a name, Cafeteria Co. for a cafeteria tells you exactly what that is. But from a legal standpoint, that's an awful trademark because it tells you exactly what it is. And there's always going to be this tension of trying to find something that resonates with consumers, but is not too descriptive. And I think that's where context really helps, because a marketing person is going to look at it completely different from an attorney will. And the AI model doesn't know who's right. And I don't know if there is a right answer. It's all a balancing act of where do a client's risk level fit. And so I think that there are, I am less of an AI kind of doomer than most. I think that it's being misused as kind of a miracle cure-all for a lot, but I think that there are some kind of good uses. I think one of those is idea generation, so iteration. So where you were trying to come up with 5 names, then you scratch off those 5 names, then 5 more, as a way of generating a bunch of kind of ideas at once for you as a human to then cycle through and figure out what fits. You can tell it a story and have it kind of get a better idea for what you are looking for. You can kind of get it to the point where you can come up with ideas that you would have eventually got to just faster. So the idea in a lot of kind of startups is fail faster. It helps you get in and out of things a lot quicker. And I think that it also helps understand some of the concepts of, before you even get to the trademark attorney, can you figure out, is this a descriptive trademark? And I think part of it is wording. You're going to have, if you're not a trademark attorney or familiar with the concepts of the spectrum of distinctiveness, which I feel like needs to always be in like quotes or something like that, or in italics, that exists. And so finding out where that mark fits on that spectrum is really going to help you and your clients understand what to expect from the trademark process, because the more abstract, the more kind of made up the word is, the broader the rights are going to be, the more descriptive, the less strong it's going to be, or maybe not even strong at all. It might not be a trademark because it's just the generic name for something. I think that it could be helpful with that, but just the key is kind of knowing what you're going into looking. If you're asking bad prompts, if you're asking broad questions, you're going to get answers that might not fit what you actually need.
Yep. All
And
good
that's,
stuff.
I think, a good
Mhm.
segue into this idea. So how do you create a strong trademark, and how does that kind of intersect with AI? And it goes back to what I was just kind of mentioning, that the model wants to tell you what you a little bit what you want to hear. It wants to give you, if you ask for a pet food company, I think the number one hit for that when I asked that question was, oh, do we actually put that slide in? But it
I think
basically
it's
was
somewhere.
like, you know, Food and Co. or something like that. That was like, I looked
Yeah,
at it, I was like, oh, that
I
is
don't see
very
it.
generic. Oh, we'll get to it eventually. But
Yeah.
yeah, the idea that it wants to give something that it thinks, oh, that's a good trademark because it describes exactly what it does. But from a legal perspective, we do have this spectrum of distinctiveness. On one end, you've got made up words, and those tend to be sometimes something you might feel like you recognize. The word Kodak, I remember hearing a story that that was picked because it did not have a translation in any language, and some of the ones they were looking at potentially, yeah, in multiple languages could have unexpected meanings, and so they came up with that. It sounds like a word that it exists in another language, but it's not. It's just made up. A lot of things like that come up. Rolex, fanciful marks. You could also do something that is arbitrary, meaning that it does not have any meaning within the context of the field you're in. So, cafeteria, awful name for a fast serve restaurant, cafeteria, great name for a phone, something like that, because it has nothing to do with the product itself. And oftentimes a generative AI model might have a really hard time getting to that, the abstraction of, oh, I want a word that has just a random word. I opened the dictionary and pointed at it. A logical reasoning model might say, well, you shouldn't do that. That's not a good idea, even though with enough kind of training, if you do tell it, actually, that is a good idea. That's what I'm looking for. You can get it to give you good ideas, but it's not something that's inherently baked into this idea of what it thinks you're looking for. Other ways you can create a strong trademark is to take an existing word and kind of move words around, move letters around, take two words and kind of mash them up. I think that that is often a good way to create new words from two existing words that might not have any meaning by themselves. Together, they even have less meaning. And I think that this is actually a place where the AI models actually do a pretty decent job when they're trying to give you ideas. They do love to mash up words together because they know that a lot of successful companies have Facebook, well, I guess Instagram's not one, but they're kind of these mashups of words you recognize, and how your brain recognizes them is something that it can do fairly well. But we'll get into why there's a lot of pitfalls to that, because just because it does it well, there's probably a reason. That's because it may look like something that already exists. That's why it thinks it's so successful. And so things to stay away from, single common words. There's going to be a lot. I mean, I think meta is now the hot word that there is in a bunch of different things, including what Facebook's kind of doing. I think that was years ago, but they're still faced with hundreds of other metas out there and maybe even thousands. I think that that makes for a really tough phrase to try to have exclusive rights on. I think also laudatory words, geographic names, those tend to be really great because they immediately tell you what the product is. This is the best pizza ever, but that doesn't tell you that your pizza, it doesn't say anything about your company or your client's company. Same thing with geographic locations. There's lots of really, especially in like the food and beverage industry, there's Brooklyn Brewery, there's Miami. It's not Miami Subs, but I think that might be a very regional reference to anyone from South Florida. But yeah, those tend to make very weak trademarks, but they also yeah, are helpful from the marketing side, but very difficult to enforce from the legal side. And then common industry terms. I think this is one that is very tricky because folks might look at it and say, well, people outside the industry don't know this phrase, or this is a phrase within the industry, but it doesn't directly describe what I do. Those words, think of who your audience is, and in some degree, your audience is going to be a patent and trademark a trademark examiner with the patent and trademark office. And if they see a word that has some meaning within your industry, first you have to tell them that and they'll ask. And then the second one is that they could deny it, even though you thought it was kind of a clever play on something within your industry. It could still be something that's difficult to protect, because ultimately, when we're filing a trademark, when we're trying to get trademark rights, we're trying to get exclusive rights in a phrase. And so if that is something that in a specific industry. And so ultimately the government doesn't want to be in a position where they're saying, well, now there's uncertainty about whether people can use this common phrase. And so that's kind of the legal backbone of why they don't want descriptive trademarks or commonly used phrases to exist within trademarks. And there's exceptions to that, but I think that that is underlying kind of what you're looking for. And a lot of the times when you're using an AI model to do that, it does not provide that context. So I think that if you are working with clients who are doing this kind of idea generation part of it, they're looking for names that, they haven't decided on one. They're looking for 15 different names to whittle it down. To training through your prompt to avoid things like this is really helpful. Tell it, please avoid single common English words. Please avoid laudatory phrases or geographic names. Like those are things that you can put within the prompt to actually help you get better results that you can then work with an attorney to actually whittle down even further from a legal perspective.
Yeah. No, yeah. Great stuff, Eric. We've got a few questions that came in that I'll kind of read off here, and I think they're good and timely for what you were just talking about. Two of them are very similar, so I'll kind of mention both and then provide an answer. Someone asked if we foresee a day when AI will be robust enough to provide reliable trademark suggestions without suggesting weak or conflicting marks, and if so, how do we know when we get there? And then a related question is, how much will AI affect the trademark search process and that attorneys and paralegals are currently doing, and to what extent will AI completely change how we file and defend trademarks? Well, I think one of the things we've already mentioned and started to see in our practice is there's more and more tools that are being created to help with the trademark clearance process that are AI based, or they say has an AI element to it, and we definitely are very active in testing and even using those tools in our practice when appropriate, and with the proper guardrails of knowing that we still need a human review on certain things. I will tell you that from 2 years ago until now, I think they've gotten a lot better. We're probably talking about a significant night and day difference to what they can find. I would say that 2 years ago, I was telling people they probably are finding 60 to 70% of what I would hope they'd find. And there was some big misses still in those reports. And now there's fewer, we're probably in more of a 80% world where it's catching 80% of the largest and most important things it needs to, and maybe sometimes more than that. So I definitely see the technology getting better. And look, in 10 years time, I think we're going to be in a totally different world when it comes to this stuff. I don't think much like, when I was in law school, we were being taught how to shepherdize using books, and I mean, literally how to learn, how to go into the library and do it. And that's a joke anymore. Right. And I think the idea that we're going to actually have to do trademark searches, by hand, so to speak, or Boolean searching or anything like that, that probably goes away, certainly in the next decade. Exactly when's going to be hard to tell, though. I think the technology it gets better over time, like anything else. And
Well,
yeah, go ahead,
yeah,
Eric.
and I think that also the fundamental question of if when there's liability for trademarks, it is likelihood of confusion. And a likelihood of confusion is based on the perceptions of the relevant consumer. And I think that that is always going to be something that's going to be tricky for a model or an AI to capture, is that it is one of the cases I always think about is that it's in the context of like whiskey bottles in a smoky bar. Well, I guess there's not really smoking at bars anymore, but in a cloudy bar, something like that, the context in which you view these trademarks is important, and the inaccuracy of the human brain to remember trademarks is important. And so likelihood of confusion is the ultimate underlying kind of thing we're trying to figure out here. And I think that is always going to be the trickiest part, because that's going to change as different zeitgeist changes, different pop culture moments change, that the AI will have to keep up with that. And I think that people will keep training models to try to keep up with how imperfect we are as humans, but I think that that's going to always be a tricky thing to mimic.
Yeah. Yeah. And thank you for the questions. Feel free, keep them coming. We'll hit them as we continue to go here. So we touched on this a bunch so far, but kind of get into this idea of we still have to use typical old school trademark clearance techniques to clear trademark generated by AI. And Eric and I have gone through this, so I'm not going to necessarily try to duplicate what we've just said. But I will tell you that as somebody that does this every day for a living, and I talk to prospective clients and existing clients for about new brands they're creating, I continuously hear the chat. They go, "Hey, ChatGPT said this is okay." And I continuously remind people that ChatGPT doesn't have trademark clearance capabilities. There are softwares out there that try to use AI for that, but that's not, ChatGPT doesn't have that built in. It doesn't have that functionality. So it's just something that if you're hearing that in your practice, you really need to push back on your clients, because that is, no matter how much they're an AI believer as to how good AI is and that it has solved the world's problems already, it has not solved this particular problem yet. And so that's just something to be very aware of. Even asking your clients, how, if they say they've cleared, because sometimes they'll say, "Oh, I researched it and it's fine." And you might ask them, "Well, how? How did you research it?" And that's normally when you'll hear they were on ChatGPT or Google or something. And the other thing is there's other websites. I mean, there's a lot of websites out there that purport that they can help you with the trademark search. You don't even have to pay them anything. Again, as attorneys, we probably know these things are red flags. A lot of clients don't. A lot of clients think they found a workaround to using lawyers, and that's fine. Look, sometimes they'll use those websites and they'll file a trademark and never have a problem because it just, for some, they got lucky basically. But if we're really trying to advise clients as to what we can do to help them de-risk a situation, none of those things are really should be taken seriously or should be used, especially if there's a
Well,
large investment going over
yeah,
here.
and I think that it's a great tool for answering questions. So I love when the client's like, "Well, I did that," and it's clear that they have like a very meticulously formatted with bullet points, and then a header that's in bold, and then it's a colon, and then the rest of it. And they send this to me. I'm like, okay, they asked ChatGPT why my advice is the way it is, and I think that's a great way to kick it off, because we always get the client on the phone and talk about the search results. And I think that that is a great moment to kind of figure out what they know and what they don't know, so that we can actually make the most of the time that we have. And so I'm never like offended by it when I see it, but I think that it also is, it helps me kind of craft the advice that I need to give them. But then for every client who is doing that, there's a non-client that is likely just kind of running with it and not asking those questions, because a lot of these it is hard to explain why the U.S. Patent and Trademark Office is different from federal litigation, which is different from how the UK might look at it or the EU might look at it, and it's a lot of different things that go into that. And I think that that's what gets really it is get easy to kind of see the forest for the trees kind of thing, and or the opposite. Sorry, not see the forest but for the trees. So I think that's something to be careful of. And here we finally got
Yeah.
to this
Yeah, I
tab.
was
That
gonna
was
say
something
this
that
is
I
the one
did.
you were looking for. Yeah.
This was it. So yeah, I asked it for to create new pet food names, and it gave me these are some good mashups: Nourish Paws, Tail Wag, Pet Bounty. I gave it a very, very bad prompt, and it kind of gave these back. But then that is a name that conveys a sense of joy and satisfaction, so much so that it is already filed by someone, Tail Wag Heaven or Haven, and someone else that's Tail Wag Planet. So you can tell it is a popular name because someone has already actually filed for it. And so I think that this is a really good example of, even though this is not for pet food, Tail Wag Haven and Tail Wag Planet, they're not for uh, specifically for pet food, but I still think that that would be something we would quickly say that's going to be a high risk. And harnesses for dogs and pet food are going to be sold in the same places. They're going to have the same channels of trade. And so I think that was one that I just was quickly said that we would have knocked that off, because that would be one that would immediately have a high risk.
Right. But for what it's worth, I will tell you, there's probably 8 out of 10 clients that would look at this and say, well, Tail Wag Feast and Tail Wag Haven, there's, I put a different word. Feast is different than Haven, and my products are different than theirs. And, and they'll talk themselves into why this would be okay. And as Eric just said, as a trademark attorney, like, we don't even need more than 2 seconds of looking at this to be like, no, like, this is going to be a problem. And that's just because, this is, to us, we know exactly what the USPTO examiners are going to consider. We know what the company that owns that trademark is going to consider. And yeah, and so that's something that the AI, it still can't tell the client, and something that Again, it's why we still have jobs. I don't know we're going to have jobs in 10 years, but for today, at least for the next few months, it's looking like we can remain employed just because of situations like this.
All right, Josh, want to go to the next?
Yeah. Yeah. No, I didn't know if I was waiting for you. I thought I saw you start to.
No, that's good. I agree.
So we kind of got into it there a little bit, but you're saying, okay, guys, well, what would you, what are the things you've got to consider? It just, just to give you an idea of when we're considering the scope of a search, what we're considering. Obviously, exact matches, things that are very obvious, those are easy. Things that are less easy, phonetic equivalents. Folks are actually oftentimes surprised to know that if you change up a mark significantly, even as you could see here with Coca-Cola versus, KOKA, and isn't that different enough? No, like the phonetic equivalent is still always going to be a problem 100% of the time. Foreign language equivalent, same thing. You can't just come up with I probably have 20 examples in my head that I'm thinking of through client situations where they're like, well, this is it's a different language. It should be okay. And I'm like, no, that I literally send them the part of the trademark manual of examining procedure that the examiners have that show that the foreign language equivalents are typically a problem. Again, there's some exceptions, but typically they're going to be a problem. Even commercial impressions being the same. So an example we have here is "Here comes the sun" versus "Here is the sun." If those are for similar or related products, that's almost likely going to be a problem every time. And that's just, you could see that's just one example. Imagine how many different examples you could have from there. So these are the types of things that if you're using a law firm to run a clearance search, they're going to have a much more thorough view and also a view of how are these USPTO examiners trained? What are they going to look for? And by the way, what do other companies look for when they're policing their marks? People are often surprised that the government can approve your application and then a third party can oppose it. And the answer is always like, well, the USPTO, approved this. So how can anybody say there's a problem? And the answer is because that's how the law works, is that there's only one examiner that reviews your mark and from an administrative perspective decides if it's okay or not. But another company can move in and challenge that. And that sometimes takes just some basically real world knowledge. Like I will tell a client, Monster Energy is a well-known trademark policer. If you file any trademark with the word monster, and it doesn't matter what it's for. I mean, you could probably file a monster trademark per pet food and they're going to reach out to you, right? And so anytime we see something like that, we will tell a client like, look, this might not seem obvious to you, but you're probably going to hear from this company. You shouldn't do this, or maybe you should think about changing something here so we don't hear from this company because we know that they police trademarks really heavily. So there's that type of issue that can come up where even if the government doesn't think it's a legal issue, even if we think the case was litigated, it might not be a legal issue. If there's somebody out there that wants to oppose the mark, they can create a lot of havoc for your client and for the application process. That said, in addition to just the federal government database, which we've been talking about sort of ad infinitum here, there's other trademark rights that exist in the market that you need to be aware of. This is less common these days, but each state government maintains a trademark database. So you can go in and file a trademark at the state level. This used to be more common with local businesses. Now everybody thinks, oh, well, my pizza shop's one day going to be a franchise, so I may as well file a federal trademark, which is fair enough. But we still see state-based trademarks being registered, especially in the cannabis or marijuana industry, where you still cannot get federal registrations on certain types of marks. So you might have somebody registering a trademark in California and Colorado or wherever other states might, marijuana might be fully legalized. And those rights might be applied at some point against somebody trying to file a federal application or somebody just adopting and using a mark somewhere. So all of the searches that we do for clients include this going through the 50 state government databases and ensuring there's not somebody that's trying to register a mark locally that could be a problem. And then finally, you have what's called a common law right in trademark law, which is that if you just use a trademark for long enough, you have rights around it. Best example I give people is if you, in certain states, you've heard of common law marriage. If you live with someone long enough, well, the state just considers you married. The same thing with trademarks. If you use it long enough, there's rights that are created. And you can actually oppose a federally filed trademark application if you've never filed one on grounds you simply had prior use of the trademark that was in 2 or more states. So you need to make sure you're doing a really deep dive, looking for everything from websites to product listings on Amazon or Alibaba, social media accounts, if you go into specific industry publications, depending on the industry the client might be in. These are all things we'd want to consider to see if somebody might have acquired some of these common law rights before clearing a mark for a client. So just a lot that goes into it. And again, something that's hard to do, or not, you can't really do with just the assistance of AI in today's world.
I
Perhaps
think that
change.
there's some kind of practical tools that you can at least, if you know the limitations of it, I think that some of the research that you can do now with some of they call it deep research or your deep searches that the AIs are starting to do, where they will attempt to do web searches that come up with some stuff that might be a helpful knockout type of thing to, if you're kind of aware of the industry, to look for prior common law uses. I think it's going to miss things, especially these models are not updated in real time. So there could be, and we have no, it's a black box. We have no idea what actually went into that training. And so it would just be an extra supplement for what you're already doing to kind of just start to look at what might already be out there in the industry, or even try to get an understanding of like, what does this phrase mean outside of my bubble. I think that those are some uses of the kind of generative AI that can be helpful, but certainly not comprehensive enough from a legal perspective.
Yeah. No, and I think, look, there's also issues with the skill of the searcher themselves, right? So the more
Right.
somebody is good at researching, so these, an AI deep research, these can all be useful things that you're using to supplement, and it's one portion of the research you're doing, and then you're also going and doing research in other places as well. So I think as the tools improve, we'll use them more and more. For right now, it's part of the mix, but it obviously, it can't be everything. So, um, so part of our job as attorneys is obviously mitigate risk. So, okay, we a lot of this presentation so far has covered that, but just sort of the 2 points that we sort of should hammer home is one, completing due diligence, always making sure things are getting legal clearance before they're getting used. And this is more for like if you have a company that's a little larger, like we have companies that have, obviously they have in-house legal teams like a GC and other in-house counsel. They have marketing departments. And what you will find is that sometimes marketing creates something and then they just start using it. And then you get then the GC gets a demand letter and sends it to you. So what we try to educate our clients on is like, hey, we need to have marketing come up to speed, and because they're going to just be existing in the marketing world where everything's moving very fast and they want to use the latest technologies. They may really want to be using AI and stuff that they're using and creating. So making sure they have buy-in to all the types of things we've talked about today is important. And we find that making sure we ask our clients to connect us with marketing folks and having conversations with them, developing relationships and explaining to them what the limitations are, at least they can use the tools in a way that is helpful to them, but then they understand where they need to kind of stop and check with legal, whether it's internal legal or external, outside counsel. So,
Yeah, and I'll tell a story about that. So I sent a client saw their name was being used by a competitor in an AdWord listing. So not as just they bid on AdWord, it's used their name as the header of the AdWord advertisement. And so they were, rightfully pissed off because it made it look like when you clicked on that link that it was going to their website, it went to a competitor. Classic kind of problem. And so we reached out to that other side, and he quickly apologized, said, "Oh, we took it down," and the client was not happy with that because they're like, "How would they just do that? Like, I know who they are. Why would they just do that? It's unlike them. I've known them for years." And we found out that it was the marketing company had been using something called an AI agent. So essentially, it was with very little human oversight, finding the cheapest ad word that you could buy for the most ROI and putting a bid on it and serving up the language and doing that all with maybe an intern kind of clicking through it to be like, all right, yeah, let's get this posted. And the result was, yeah, the best thing to bid on is your competitor's trademark. But from a legal perspective, yeah, and we actually ended up, yeah, that marketing company, I believe, fired, and was in some legal trouble for a while because that is just not a mistake you can afford to make nowadays, is something like that. And if it's all on autopilot, that doesn't mean you can't blame the AI for liability, you're still responsible for it. And so I thought that was one that I was like, oh man, like that is what we're dealing with here, and it's kind of moving at such a pace that if that's going to be happening and you might not even know about it. So I think we'll talk more about monitoring, I think, if we have time. But I think that's one of those stories that I was like, oh yeah, that's a huge problem if that's happening outside of just this kind of small instances.
No, I think the minute you get inside any marketing team in a company, you realize that there's not a lot of legal guidance, or they're not thinking, they're thinking more, I have to hit sales numbers, I have to hit whatever metrics we're trying to hit as a marketing team. Legal's just going to slow us down, so let's avoid them. And I appreciate that, but the more that companies are going to start to use AI, they're going to run into these problems. And especially if there's any GCs on this call, making sure you get with your marketing folks. Or if you want Eric and I to go in there and do the work for you, we're happy to. But it is something we see just time and time again, that as soon as we educate people, normally it's pretty good, and we can get good working relationships with marketing. It makes things a lot smoother for any larger client. I'm going to go ahead and skip this slide just in the interest of
Yeah.
time to get to some of the other stuff. So other ways using AI for trademarks can be risky. That sort of explains itself. We got into this a little bit, but Eric, maybe you want to take from the top here, and then I can jump
I
in.
mean, so trademark enforcement, there's ways that ChatGPT can help kind of hone in the message of what you're trying, ChatGPT or any of the generative AI models. It can really help someone who does not have legal experience draft a very convincing looking cease and desist letter. There are a number of tells that I have gotten. I've now gotten multiple responses to my letters, and I can always tell when someone just kind of popped it in ChatGPT because of the formatting, because of the way it's written is. But it does help, and it does empower people to feel like they can do it, but the content is always something that you can tell, oh, this did not have the eye of someone who is looking at this from a legal perspective. But it does, I think, yeah, that can run into a number of issues, especially with kind of smaller teams. To solve a problem, they might be shooting out these letters, and they can run into a lot of kind of liability if they're wrong, because yeah, it won't tell you, well, they could have been using it longer, they could have defenses, they could have a number of other things. We see it a lot with USPTO office actions where I'll have a client that says, here's what I want to say. And they'll say, well, that doesn't apply to you. That's the sophistication of the users. That is a good factor, but that's a very small factor, and in some cases does not apply at all in this context. And I think that's where I'm going to go back to the word context over and over again, because that is so
Yeah.
important. And then litigation, I do a lot. So oppositions and cancellations in federal litigation, it is very tempting for folks who don't have the experience or the knowledge to use this to make a very convincing complaint or response to a complaint. And it is always, to me, very obvious. We got Josh, I think a
Yeah.
97-page answer recently that had a executive summary. An answer is supposed to be a one-sentence response to each of the complaints. And so usually it's like 2 or 3 pages. This was 97 pages, and we kind of instantly knew, okay, we know what we're dealing with on the other side as far as kind of just this is completely inappropriate. And then they didn't even include, they didn't serve it on anyone either. So it was even just deficient.
That was a pro se person, for what it's worth.
Right,
This
right.
wasn't
But
another
it's very
lawyer. But yeah,
easy for
still,
folks
yeah, they think
to get
they're
to that point.
empowered.
Right.
Yeah, yeah, they're empowered
And
to do
the
it. Yeah.
only people who I've ever been opposite of that have been disbarred have been, and no offense to any criminal attorneys who are on the call, but criminal law attorneys that were doing a trademark case and then consequently got disbarred. There were two of them, and for kind of, so a lot of this stuff does empower people to do new areas of law. I think that's great. More the merrier in trademark law, but I definitely want to make sure that you have the expertise and the knowledge to go through some of these very complicated federal rules that exist in the field.
For what it's worth, I would never get into another area of law using ChatGPT as my source. But that's just me. I mean, I just know that I could see the limitations in the trademark world when we kind of play around with it. And I'm like, well, this is not right, or this isn't even close. And so I would never trust it for anything else.
I once asked it for a case law that was two trademarks, because I was just trying to test it out. Two trademarks that were different in one letter, but were found to be not confusingly similar at the trademark trial and appeal board. all information that was fed in at some point, because they give you trademark trial and appeal board stuff, gave me a real case, completely wrong case holding. I was like, that is not the holding of that case. And so you got to be
Yeah.
very, very careful of that, because people are now getting into sanctions and ethical issues with doing that. That's kind of widely reported that judges are furious when that happens, and a
They should
very
be.
easy way to get into a lot of trouble.
Yeah. Yeah. Hey, look, someday we're going to be replaced by these robots. I'm convinced of it, but it just isn't there yet. It's just,
Yeah.
yeah.
Yeah, no, I think that, yeah. So Josh, we've got a little bit of time left. I
Yeah.
got a couple of really good questions in the chat about
Yeah.
how practitioners, especially can help with the actual drafting of a trademark application. Is there ways to use AI to help with that? I've got one thought on that, and then we can kind of get into some other stuff. But I know we only have a few minutes of time left, so we might need to do like a completely,
We promised
yeah.
everybody our one favorite thing, so we'll have to get to that. So
Okay.
but yeah, go ahead. Yeah.
Well, no, it is one of the questions was, are there ways to kind of speed up the process of that? And I think that the answer is there is, if you already are very comfortable with the law, and at that point it is just a matter of speeding it up. Can you
Mhm.
replicate something you would have done manually just using an AI? And I think a great example of that is the identification of goods and services. That is the fundamentally, you need to understand what your client does. And I think that learning that in any manner you can, read their website, but then also asking a AI model, what classes do these fall into? It gets it wrong very frequently, but it can at least help you with that idea generation. What could the client be looking at? Because you may not be, no trademark attorney is an expert in every single field, but we're expected to be, and we need to be
Mhm.
to at least the small enough extent to represent our clients effectively. And so I think that what we have not seen yet is that the Patent and Trademark Office has preset lists of goods and services. It is the current models are very bad at meeting those to actually give you something that will fit within the USPTO's pre-approved language. So the person who asked that in the chat, is there a way to make that? The answer is right now, no. I know a number of companies are working on it. I was just at a conference that someone claimed that they had an MVP. They're working on getting that going. So I will definitely be keeping an eye on that. But right now, the foolproof, if there is a foolproof way, is manually ensuring that your staff looks to see if it fits within the USPTO's standards. And yeah, and AI is not going to help with that, unfortunately. And right now, even with office action responses, it's just there's not enough. There's very specific arguments that should be made in office action responses, and I think the models all ignore the finer points and just try to answer every possible question and really ignore some of the really important things.
Yeah. I mean, a great business idea is somebody to go out there and really develop, and feed an AI all the important things you need to consider with like an office action response and all the things that might have worked in the past. And I mean, there's a way to create a model. It just hasn't been done,
It goes back to context. I think that's
Yeah.
going to be the hardest part is,
Yeah.
does the person using that model have enough context
Yeah.
about the law to ask the right questions? And if you
Yeah.
do, then you probably don't need the model because you already have
Yeah.
the context needed to kind of make draft, but you can maybe write your argument faster, and that'll save people money. That'll kind of allow you to do more work. So I think those are the places where I could see it becoming more quickly usable, is kind of to replicate things you already know how to do just faster.
Final rules. These are just our individual rules. I'll harp on it because I keep doing it. I don't like using AI to create logos. I'm going to show you exactly why. Last summer, I told my kids they need to start a business because that's what we're going to do in this house. And on the left, you can see. So my 9-year-old went on ChatGPT because he's like, well, I'm going to make a logo. So what am I going to do? I'm going to go on ChatGPT, and you can see what he created. Um, we did a little research for him just to see, if it was clear to use. And we found the one amongst others on the right. And so again, you could see where the AI used some existing logo to come up with this one. And I would argue that from a trademark perspective, there's a lot of similarity here. Copyright, it might be a different story, but again, when you look at if these were sitting next to each other and they were both using the sign, down the road from one another, you would think that the original here might be a little bit upset with my kids. Nevertheless, I don't think anybody was suing a 10-year-old for his ice cream and lemonade stand, but you can kind of see what the limitations, might be in creating logos. And Eric.
Oh yeah, and I think don't ask AI questions you don't already know the answers to or can't quickly verify. You can ask it to give citations, and if it does give you a citation, you can click on that citation and actually read it and confirm it. Great. I think that helps provide that context. But otherwise, that's where people get into trouble is they go down these rabbit holes of just assuming it told me you a convincing answer. So if you go by that basic rule and I don't know, just a level of mistrust of it, I think that there are some really kind of cool things you can do with it, but just kind of no underlying that you really should kind of trust your instincts and not the AI model.
Very good. We really appreciate y'all being here. We're at time, so uh, you don't have to hang out any longer. But if you, what we'll do is, if you have any questions that we didn't get to today, you could see our email addresses here. You could follow us on social, but you could always feel free to drop us a question. Eric and I are happy to see if we can't answer questions that come up that we're not able to get to in the hour here that we have together. And obviously, if any questions come up in your practice or in your as you go forward about trademarks, we're happy to answer those.